All right, hello everyone. Welcome to Uncivil Law. I hope you're having a great day. I'm still sick, but I'm getting better, which is plus. And for today's stream, I thought what we'd do is I saw this pop on my feed. Apparently, I'm assuming some district judge nominees are being questioned by the Senate, and I thought I'd answer some questions to see if I can play with these people on these levels. So I thought that might be fun. So we're going to turn to Senator Kennedy, who's going to ask these nominees for the bench some questions, and we're going to see if Uncivil can play this game. All right, this sounds like fun. So let's go ahead and do that.
Thank you, Mr. Chairman. I'm sorry, I can't see that far.
Bragdon, me?
Who wants to volunteer?
I'm available. I'll volunteer.
Senator, I would be happy
Let's
to
just
go
start in the
first.
middle and we'll work to the end. Tell Mr. Also,
Orso, yes. thank you,
I'm
Senator.
sorry, I really can't. I guess I need to get new glasses. Mr. Orso, let's suppose, imagine this situation. Small printing company, they manufacture envelopes, stationery like that sort of thing. 20 employees, small operation. They take customer orders, go in the back, print the stuff. They wear uniforms because the owner wants to promote his company with the company logo. Employee shows up one day in uniform, but she's wearing a burqa. And the owner says, you can't wear a burqa here. And the employee says, yes, I can. And the owner says, you're fired. Tell me how you'd analyze that case.
All right, I'll tell you how I'd analyze that case. All right, so there's a lot of information that we don't have in this thing, but we'll give it a shot anyway. All right, so we're thinking potentially it's civil rights violation, Title VII, discrimination potentially on the basis of religion, maybe national origin. For Title VII protection. Now, you need to know some more information here, to be honest. The burqa, by its nature, is a full covering of the entire body. And the uniform policy of the business appears to be a religiously neutral policy in the first place. So I suppose let's work through this in a Title VII analysis and see how that works. So if this employer or this employee wanted to bring a lawsuit, the employee would first need to claim that they were discriminated against on the basis of religion or national origin. The employer would then say, no, we really fired them because of reason X. And then the person suing would say, you didn't really fire me because of reason X, you really fired me because of religion or other protected class. Now, in the way the hypothetical is provided, with the limited information that's provided, the employer appears to have a religiously neutral reason that is, it's not discrimination on the basis of religion, right? They're not discriminating because the person's wearing a burqa as such. They're discriminating against the person because they're not wearing the uniform. I suppose if they had their logo on the burqa, that could be more interesting. But, that's not the thing. Religious neutrality, as long as things are religiously neutral, you should be fine. So my thought here would be, I guess, for lack of a better idea, I guess I'd start running the Title VII analysis, but based on limited information that's available, the employer's probably okay. It would also be helpful to know if the employer has ever allowed other deviations to the policy for other religious reasons, which is unclear. So that maybe you could show some animus to this particular religion. Right. So it'd be helpful to know if there's anything that suggests a pattern of conduct Of course, with a 20-person shop, it's unlikely, but that'd be helpful to know. So those are my thoughts initially. But yeah, those are my thoughts. Okay. You'd also, Boomhurst says, like also like if it was due to a safety consideration would be a valid basis as well because of the nature of the machinery as possible. Yeah. So those are my thoughts on the issue. Let's see what the nominees for the bench have to say on it.
What questions you need to know? Who would win? Who would lose, according to Supreme Court precedent?
Sure. I would likely look first to Title VII of the Civil Rights Act of 1964, since
That's
it's
correct.
an employment case.
And what's Title VII say?
It says that a person cannot be discriminated against in employment on the basis of race, color, national origin, religion,
Right.
gender.
So far, so good. It's like, well, the nominee and I both agree on the right place to start looking. That's a good start. All right, carrying on.
And then I would apply the facts of that case, pursuant to.
What facts would you have to know?
I'd have to know if the wearing of that burqa was indicative of any potential religious, closely, sincerely held religious belief. And then if so, would analyze it from there.
Fair enough.
What if the employer said, my customers won't like it? Is that a justification?
Yeah, my customers won't like it is not going to do it. First of all, I don't even know if that makes sense. What scenario is this? My customers won't like it. We're working in a print shop somewhere, right? Like, who cares? My my customers won't like. That's no. No, Senator Kennedy. You're sounding suspiciously like you're saying, "Oh, my customers won't like it. Oh, my customers have animus. Oh, therefore I'm doing it because of animus." Oh yeah, no, that's not going to work. No. Among the many reasons, that's definitely not one of them. No. But thank you for playing anyway. No, absolutely not.
I don't believe that would be sufficient justification to discriminate against someone based on religious belief. I think you'd have to take into account whether the employer is providing any type of accommodation that allows for that person to.
What if
to
the
work there.
small business owner said, it's dangerous? The
Yeah, there you go.
employee might get the burqa caught in the manufacturing apparatus.
Well, yeah. Well, I mean, I just based it off the hypothetical where you said the employer's motivation was that they were wearing the logo to bring attention to their business. So it's like, oh, the burqa's going to hide the logo. So I just it's like, okay, you're changing the motivation. Now I'm doing it because of safety reasons. If the safety reasons are real, which they very well might be, then, fair enough. Yeah, that works. Again, it would be helpful as you're analyzing whether or not the safety considerations are real. It'd be helpful to see if other aspects of their policy are reflective of that, right? It wouldn't just be the uniform policy, although that would help. It would be other aspects of like loose hair, loose clothing, loose items. Maybe other items are not permitted because of the machinery. So it'd be helpful to know what other steps they're taking, right? Because if they just sort of out of nowhere say, oh, it's because of safety, and there's like nothing else in their policy that's reflective of that, then that looks like a pretense. So the thing that I'd be looking for at this point is to see what other things in their policy do or do not exist that reflect that this is an actual genuine concern as opposed to a pretense concern. So that would be where I'd go with that.
I think I would have to look at the case law if there's anything similar on that, but my instinct is that, in terms of protecting the safety of employees is a valid concern of an employer.
Okay, fair enough. David, I really
Bragdon.
can't see. I need to do
It's
something. but-
Mr. Bragdon. David Bragdon, thank you.
Mr. Bragdon, tell me about supplemental jurisdiction.
Really? That's a pretty easy question. Supplemental jurisdiction is the principle in federal court that a federal court can hear state level claims as long as they're coming along for the ride in relation to the federal level claim. So as long as you're in federal court on a federal question jurisdiction and you want to bring along state level claims, you can bring along the state level claims because you're trying to adjudicate the entirety of the case. It's in the name of judicial efficiency. So it's not that hard, right? I mean, it's like, yeah, the federal question, what gets you into the federal court in the first place, and then you bring along your state level claims of causes of action for the ride so that you can adjudicate everything in one nice, neat package. It's not, I feel like I'm being insulted by this question. This is too easy.
Supplemental jurisdiction, I am having trouble remembering that term because it does not come up in criminal practice very much, but I believe
Really?
it's
Don't come up in
jurisdiction-
federal district court
Absolutely.
every other Thursday.
And I will certainly carefully research any issue that were to come before
Wow, that's
me
not great.
If I'm
I mean, I appreciate that he's a criminal lawyer, but he doesn't know what supplemental jurisdiction is. That's rough, man. That's a pretty basic one. Oof. That's not great.
It used to be called pendant jurisdiction. Does that help?
but I think it's jurisdiction that
Pendant jurisdiction. Wow, I haven't heard that one in a long time, man. That's way old school. That's super old school. Yeah, if you ask me what pendant jurisdiction is, I'm not sure I could come up with it off the top of my head. Because that's old school. Woof.
builds on jurisdiction. I'm thinking it builds on jurisdiction of another party who's already
No.
properly before the court.
That's not what it is.
But I
No.
don't specifically remember Senator Kennedy.
Okay.
No.
Do you know?
I hope.
Senator, I would say that is my understanding as well, and I don't have too much to add in my years as an AUSA. I haven't been working on that recently.
Again, this is not super encouraging. I mean, the AUSA is also a criminal lawyer, but that you don't know what the term supplemental jurisdiction is? I mean, it's pretty basic, man. Did you forget your basic Civ Pro? This is wow, really? Okay, I'm apparently more qualified than two people here that want to be on the bench. Damn, all right.
Who knows the answer? What's turn your
This
mic
is
on for me,
Judge Rodriguez, and so I am a sitting U.S. magistrate judge right now, so I think
I would really, really hope the sitting U.S. magistrate judge knows the answer. Lord have mercy.
that I'll step in for the panel. There was a recent Supreme Court case on this. So supplemental jurisdiction is when the court would have original jurisdiction over some sort of federal question, but then there is a state question. And so that's where the court can exercise its discretion over supplemental jurisdiction. A lot of times where that comes up is if something gets kicked and there's only state law claims, does the court exercise jurisdiction otherwise over those state law claims? And there was a recent Supreme Court decision on this that basically said that the court could.
Oh, U.S. magistrate judge going for extra credit. The question was just, what is it? And the U.S. magistrate judge is actually bringing recent precedent into this. That's nice. Yeah, the magistrate judge might be qualified.
Get divested of its jurisdiction if a plaintiff dismissed everything, all of the federal claims. And so it goes back to a jurisdiction issue, and that's what you would be normally looking at.
Okay.
So far, I'm crushing this interview by the U.S. Senate, I'd have to say. Compared to my colleagues over here, I'm crushing this interview. The magistrate judge did bring a point I did bring in by bringing recent Supreme Court precedent as it points to her. But I'm doing better than the other three members of the panel. Woof. Pendant is plaintiffs adding state causes of action. Ancillary claims are state court defenses. Yeah, that's old school, man. But okay, fair enough.
We go back to Mr. Rousseau. How do you amend the Constitution?
Really? Seriously? Article 5. You need 2/3 of the Congress or 2/3 of the states and then you need to be ratified by 3/4 of the states, either in the legislatures or by the voters thereof. Take your pick. Oh my God.
Senator, I think you'd look to Article 5 of the Constitution and follow the instructions for 2/3 of the legislature or 2/3 of the states.
Okay, fair enough.
That's half of it. Lord have mercy.
Let me move to the gentleman to your right. What's the difference between a preliminary and a permanent injunction? And
I really want to be a smartass here and say one's preliminary and one's permanent. But in the interest of not being a complete smartass, I'll give a more thorough answer. A preliminary injunction is temporary. It happens early in a case. Depending on a lot of factors, it can happen extremely early in the case. And they can change during the case as the needs change for the case. So they can change. A permanent injunction almost always comes at the end of the case when everything's been adjudicated and is a final injunction that requires them to do or not do a thing, because that's what an injunction is. I suppose I could also add, as long as I'm here, that a TRO is not appealable, although a preliminary injunction is, and a permanent injunction certainly is. And the Supreme Court's recently been chiding the lower courts on labeling things TROs that they really think are preliminary injunctions to get around this problem. If you want some extra context on it, do you want the 4-part standard for the injunction? It's the same 4-part standard for all three of them. They're just handled differently, or just evaluated differently. But you need for the 4-part standard, you need that the likelihood of success, the burden on the one party, the burden on the other party, and what's in the public interest. Does that help? Okay.
how you decide them, Counselor?
A preliminary injunction, well, let me start with a permanent injunction would be a final judgment in the case that occurs
Right.
after the completion of all the litigation.
What do you have to let's start with the preliminary. What do you have to prove to
Sure.
to
For a
judge?
preliminary injunction, there's several standards the court looks at. You're looking at irreparable harm.
Nice.
You're looking at the likelihood of success in the merits in the ultimate case as it goes through court. You're looking at balancing the equities of the parties. So those are some of the factors the court considers and whether to grant that. And it's essentially, the idea is, can you keep things in place while the litigation is pending?
What factors do you look at for a permanent injunction?
Same factors.
Well, the permanent injunction would depend on the relevant law or action that's being considered.
Yeah, but what factors do you look at for a permanent injunction?
It's the same.
So you, for a permanent injunction,
You
I
look at
think
the same
that-
factors, don't you?
That's what I said. Yeah, just Kenny says the same factors. Yes, it is, Senator Kenny. It's also the same factors for your TRO. They're just evaluated a little bit differently, with a little bit more credulity or skepticism at different stages. But yeah, it's the same factors. Thanks, Senator Kenny. Yeah.
I think that, in my mind, a permanent injunction depends on the underlying statute or relief that you're taking, and it can vary based on the kind of case.
Well, in a
that's
preliminary injunction, you're asking, is the plaintiff or the movement likely to succeed on the merits?
And
In
so-
a permanent injunction, you're asking, has the party succeeded?
I mean, yeah, that's only practical change. I mean, but you can still say how likely is it? The only difference is at the end of the case, it's 100%. because you've reached the end of the case, so you know for a certainty. But yeah, the likelihoods are looking real fucking good at the end of the case. So yeah, it's the same factors. Yeah, I do that. What else you got?
On the merits.
Correct. My only point is what the merits are is going to vary based on the kind of case.
Fair enough. Counselor, tell me about class actions. What do you?
That's a very broad question. Tell me about class actions. I mean, yeah, what is the question here?
What are they, and what are the elements of you have to prove?
Oh Lord, this one's actually could be a little bit challenging. Let's see if I can do this off the top of my head. Okay, so for a class action, you need a group of people that are similarly situated and have a sufficiently in common set of interests to adjudicate them all together. You need typicality, you need commonality, you need common redressability, you need obviously some named class plaintiffs that are also typical of the class. Let's see, what else do you need? Typicality, commonality, what else? The size makes it impractical to do them individually. What is typicality? Well, the typicality is the degree to which the plaintiffs have are in a that their legal issues are similar, as opposed to commonality, where their factual issues are similar. So that the typicality is that their legal issues are typical, are in pair, whereas commonality is that they're factually similar. Yeah, Lord, I'm dying here slowly, but I still know the answers. But there's like 5 factors, and I'm only getting 3 of them. So yeah, let's see what else we got.
Senator, I believe you're referring to Rule 23. So in order to have a class action, you're allowing one plaintiff or just a few plaintiffs to stand in for a class of a larger number of individuals. To bring that class, you have to meet the factors that are set out, the elements that are set out in Rule 23. So we're looking at numerosity, typicality.
Well, I said numerosity implicitly. I just didn't use the term because I said it had to be so big to make it unwieldy to bring them all individually. That's called numerosity. So I just didn't use the magic word, but I described it. Close enough.
Factors that are set out, the elements that are set out in Rule 23. So we're looking at numerosity, typicality, representation, numerosity, commonality, I believe, but those are some of the factors in it.
I didn't realize I'd gone this far over. I'm sorry.
This concludes the entrance exam. Now we'll
Well, I did pretty good. I got most of the same answers she did. I didn't use the word numerosity, but it's like it has to be so big as to make it unwieldy. That's numerosity. I just didn't use the word to describe it. So I think I did pretty well. I think I passed my interview to be a federal judge. So I think I did okay. I wonder if there's more of these. That'd be fun to watch more of these. Yeah. All right. Well, maybe I'll sign off and just see if there's more questions later. We can do more questions from the Senate. If I'm available, U.S. Senate, I'm available. I know the answers to these questions. If I wasn't dying, I would have been a little bit quicker on the uptake. All right, I guess I'm going to sign off and try to go to the gym today. I haven't been to the gym now, and I didn't go 2 days ago and I didn't go yesterday. I kind of wanted to go to the gym today, but I don't know if I can. I'm still kind of recovering from the sickness, but we'll be on more with some other stuff, I guess. I'll sign off for now. I'll tune in later. Until later, I've been Uncivil. Cheers for now, and goodbye.